My name's Elizabeth Drummond. I'm one of the law tutors at Mansfield, and I'm really happy to be doing a mock law interview to show you a little bit about what you could expect if you were called for a law interview here at Mansfield. We are going to do this over Zoom, so it's a little bit different from what you would see in person, but it's not that much difference. It's always about a conversation to see what a candidate's strengths are across the admissions criteria. So let's move on to the interview. So Sruti, do you want to introduce yourself?
Yeah. Hi, I'm Sruti. I'm a second-year history student at Mansfield. So coming into this mock interview, probably similar to a lot of prospective law students that, I didn't do an A-level or anything like that. So yeah, going in blind.
Yeah, and that's a really important point to stress before we start, that we never expect anyone to have any law knowledge before they come into an interview. And that's something that we take very seriously. You shouldn't need to have law knowledge before you come in. As it happens today, we're going to use a text that's very much based on an English statute. That probably wouldn't happen in the actual interview. We'd either have something that we've made up or we would use a different sort of text altogether. But for the purposes of this interview, I've got a short text from a statute that we're going to discuss together. So always at the beginning of the interview, we would make sure that everyone's happy with what we're going to do. I'd probably stress that the time in the interview itself is quite short. So sometimes we tend to move from question to question quite abruptly, it can feel like. That's not something to be worried about. It just means that we've heard what we need to and we're going to move on. So yes, don't let that stress you out. And so then we might talk about perhaps something that's in the candidate's personal statement or anything else that they have expressed an interest in. But this interview, we're going to start by talking about a short text. So can we have that on screen, please? And Shruti, if you let me know when you've read it and if you have any questions about any part of it.
Yeah, sure. Yeah, read it.
Fantastic. What do you think would be an example of a time when someone would be guilty of theft under this statute?
If someone saw a car on the road and stole that car, broke into the car and drove away with it and never came back to return it.
Yeah. What if the person broke into the car and drove it away because they wanted to go to the cinema and they said, well, I'm going to come back later on?
Yeah, I don't know that someone, well, the owner of the car might not find out at all that the car has been gone. So you very well could maybe do that, drive away with the car, and then if you return it in time and no one has noticed.
Let's suppose somebody does notice. Would the person who took the car be guilty of theft in that case?
No, not theft.
Why not?
Because it says here, a person is guilty of theft if they dishonestly appropriate property belonging to another with the intention of permanently depriving the other of it.
Yeah. So let's take another example. Let's suppose that I have a bus ticket. It's one of those tickets where you get 10 trips on the ticket, and it's a ticket for me to go on the bus to London and back. And let's suppose that I leave it in my room, and a student comes for a tutorial with me, and they think to themselves, oh, I've got a job interview in London. I'll borrow this bus ticket. And the next day they come back and they put it back on my table. Do you think that student is guilty of theft?
I'm not sure about that one because it's not a permanent deprivation because the ticket is returned and then maybe they've not used up the last ride on that ticket. So there are still rides left, but they have permanently deprived you of like at least one of those rides that the ticket allows you to have. So yeah, I'm not.
Good, yes, it makes it difficult, doesn't it? Do you think it would make a difference if they took rides 9 and 10 as opposed to, say, 1 and 2?
Yeah, I think it would because it like it depends on the amount, like how much it would disadvantage the person who actually bought the ticket, because they might be they themselves might have a job interview the next day and they need a ticket, and they can't use that ticket because all the rides have been used up. Whereas with the using the first and second rides, because there will still be rides left, they might not be immediately disadvantaged.
Mm-hmm. Okay, so that's an argument for why it would matter. If you were arguing on the other side and you wanted to say there was no difference, what would you argue then?
Well, I mean, when you're paying like a set amount for 10 rides, each ride costs the exact same, financially. So, what you're being deprived of financially is not any more or less, like in a direct way.
Mm-hmm. Good. So we've worked out then what we think is difficult about this bus ticket example. And now we need to say, let's suppose you're the judge. What do you think you would want to say in this situation? Would you want to say that is theft, or would you feel like you had to say it wasn't theft?
If the person returned the ticket and used one ride, I probably would, I would not say that it is theft.
And why would you say that?
Well, I guess, I mean, if we are assuming that the context that you gave me is also true here, that this person had a job interview, well, I'm like, if I was a judge, then maybe I wouldn't consider it theft because it's only one ride on this bus ticket. That I would probably want to go for something, for a like lighter sentence. Yeah.
Okay, let's suppose that, just to make it easy, let's suppose that our choices are either they are guilty of theft or they are not guilty at all. And then let's not worry about how much of a sentence they should have.
Then they are guilty of theft.
So on this definition, we said that the difficult thing was that they always intended to bring the ticket back, and they did bring it back. So how would you argue that it does or does not fall within the definition of theft here?
Well, it does fall within the definition of theft because a right has been dishonestly appropriated, and it has permanently deprived the person of it. It's also, I mean, it says here it does not matter whether or not the appropriation is made with a view to gain. So perhaps the intention of the theft does not matter as much as the consequences of it. And then the last is any assumption by a person of the rights of an owner amounts to an appropriation. So in that case, someone using that bus ticket as their own when it is not their own also amounts to theft. So it fits all three criteria.
So in your reasoning there, you've said that they dishonestly appropriated the ride. Do you think that works under this definition? What is it that must be appropriated?
The property, which is the ticket. But then how would you want to define property? Because the property could be defined as 10 rides rather than one ticket alone.
Good. So it depends on how we define the property then. And if we define property as 10 rides, then I agree with you that we can say this person is guilty of theft. Do you think that property here should be defined as the rides that we can get, or should it be defined as the piece of paper?
Maybe I'll read through the text again. I'm not sure how we would define property here. I'm inclined to say that it would be 10 rides rather than one ticket alone, because I think you looking at it as like, like one ride in a 10 ride ticket, and then like, that one ride being considered like, the whole of the ticket is not necessarily like proportional to what is like, the actions of the person who is, being accused of theft. Yeah, if that makes sense.
So you say that there's a difference between the rides and the ticket? And
Yeah.
it's about the proportionality? Can you just go into
Yeah.
that a bit more for me?
So I suppose one ride is like 1/10 of the ticket rather than one whole of the ticket. That's what I'm thinking of.
So they've stolen, in a way, if we go on your reading, they've stolen part of the value of the property. Is that what you're saying?
Yeah.
Yeah. So they've stolen part out of it.
Yeah.
Yeah. But we're still saying, on this reading, we are saying that the ability to get the rides is the property.
Yeah.
Rather than the bit of paper. Yeah.
Yeah.
So that's our sort of, and you can see how in that reading you sort of said, okay, is it dishonest? Have we appropriated, and what is the property belonging to another? Let's look at another example. Let's suppose that my neighbour likes to play football in his garden, and one day he kicks the football over the fence and into my garden, and the football lands in the middle of my lawn.
Mm-hmm.
And I go out there and I look at it, and he calls over the fence to ask me to throw it back. And I think to myself, no, I don't want to throw that football back. And I walk back into my house and I leave it there. Do you think I'm guilty of theft of the football?
No.
Why not?
Well, actually, I mean, because I was going to say that that's not a dishonest appropriation, but then maybe it is, because I suppose any reasonable person would throw the football back. But so, like, I mean, or I don't know, maybe this is going on to other stuff, but that's sort of like social contract when you're living next to someone, that these are like, this is just how you live with one another. But yeah, so I'm not sure.
So
But then
yeah, go on.
I was just thinking about all the other criterias, is that, well, I suppose it does not matter, like, your intention behind taking that ball. But then by taking that ball, you're not necessarily asserting that you're the owner of that ball. Maybe it's a gesture towards your unhappiness with the ball being thrown into your lawn.
Yeah, so okay, you've identified 3 possible issues here. So dishonest and appropriation that you think are issues, and also concern as to whether within that idea of appropriation, whether I've actually assumed the rights of an owner here. So let's take the appropriation issue first. What do you think would be the strongest argument we could make for the position that I have appropriated this football?
Well, this ball was not bought by you, and this ball was not given to you. This ball was just accidentally thrown over your lawn, and you just took this ball into your house and kept it. So you have permanently deprived the other person of this ball, and it's a dishonest appropriation because you're not the owner of the ball, because you have not bought it, or it has not been given to you.
Yeah. And what do you think would be the strongest argument that I could make to say I haven't stolen this football?
Taking the ball does not necessarily mean that you have an intent to permanently deprive the other person of that ball.
I have to say, cross my heart, I intend that person never to have their football back again. I am sick and tired of trying to sunbathe and being worried that I'm going to get a ball on my head. So let us say that I am required to tell the truth, and I say, I do not want that person ever to have their football back again. And when they came round and knocked on my door and said, may I walk into your garden to get it? I said no.
This is terrible. No lawyer would advise you to say that in court. Do not be that honest.
Well, I have to. I have to tell the truth in court. Let's suppose we have a magic machine that will zap me and make me tell the truth. So let's suppose we can't really get around that.
I might have a read through the criteria again and I suppose we could argue that it is not theft, given that the ball is in your property and has been thrown into your garden. So a bit like finders keepers, and this ball has been, you have not brought this ball into your garden.
Mm-hmm.
This ball has been thrown into your garden when it should not have been. And it infringes upon your right to use your property the way you want to. Mm-hmm. So, taking the ball is sort of, assertion of your right to your own property.
Mm-hmm. Mm-hmm. Yeah. So what are we pointing to in the statute there to base your argument? Because I think this is a coherent argument that the ball just landed on my land. What are we pointing to in the statute to say that is the right reading of this particular provision?
I think criteria 3, any assumption by a person of the rights of an owner amounts to an appropriation.
And why is that? Why is that so important?
Well, you are the owner of your land, and so anything that is on it is yours.
Perhaps.
Maybe.
Let's suppose that's not true. Let's suppose we can't say that the ball just from landing in my garden becomes mine, because I think that might make things quite difficult, mightn't it? It would assume that if I drop something in the street, it becomes public property. So I think that would be a difficult rule to have. But what else is it about provision 3 that makes us be able to start building an argument about the fact that I didn't sort of actively take this ball? I have done nothing.
Maybe it says something about the other person, that if they throw the ball into your land, then they have some claim to your land, and then they can use it, as they want, and that might amount to an appropriation because it is not their, like they are not the owner of your land.
I think I don't think we can say that they are appropriating my land by throwing a ball onto it. I think in provision 3, I think what it's saying is any assumption by the person accused of theft, so that's me. So it's provision 3 is saying an appropriation would happen if there had been any assumption by me of the rights of an owner over the ball. So why are we going to say that my inaction in the face of this flying ball doesn't amount to that?
Well, you're not throwing the ball back, but that does not necessarily mean that you're taking the ball away, because the ball was thrown into your property and it's just staying there.
Yeah, I get your point. Super. And then let's suppose one other example. Let's suppose that I go to a manicurist. I'm very excited because it's been locked down for a long time. So I go to the manicurist and my fingernails are in a terrible state. So the manicurist clips my fingernails and I pay and I leave. And, she pays them up all nicely and everything. After that, sort of 6 months later, I discover that this manicurist was keeping all of the fingernail clippings, and they have now made them into an artwork which says something extraordinary about artistic expression during the pandemic, and it's now very, very famous, and they sell it for a large amount of money. But myself and all the other clients are very upset about this. Do you think that we can say that the manicurist was guilty of theft?
We probably can, because if the manicurist had not told you to begin with that this is what she's using the nails for, then it is your property that she has dishonestly appropriated, and she has permanently deprived you of your nail clippings. And I mean, well, I think it's the third criteria where it says any assumption by a person of the rights of an owner amounts to an appropriation. I suppose that is where, we could say that she is not guilty of theft because she might be the creator of the art, but she's not the owner of the art anymore because it has been sold for whatever, for profit.
Let's suppose that we catch up with her just before she's going to sell it so that we can get that out of the way. So she has used all of these to make this sculpture or whatever it may be. It sounds heinous. What do you think might be the weakest points in my case of theft here? Do we have any concerns as to whether any part of the definition might not be satisfied here?
No, I think all the criteria are satisfied for theft, but I suppose an argument that you could put forward for why this might not be considered theft is maybe even though the criteria says that it does not matter whether the appropriation is made with a view to gain. If we look at other intentions behind it, then maybe we could make a case for freedom of expression, artistic freedom, and maybe also a case that once a nail clipping has been removed from your body, it is not your property any longer.
Yes, I think those are two big issues, aren't they? So do I really own my fingernails? What argument would you prefer on that point if you were the judge?
I think I would strongly consider the argument for the kind of ridiculous situation of whether your nail clippings are your property after they've been cut off. But I think that's a difficult question to make because I think nail clippings might not be, but it might set a precedent for other it might have effects on other cases where parts of people's body parts might have been removed and whether that constitutes theft or not. So I think I think that would maybe lend more strength to our argument that it is theft.
Okay, so yes, I think you're absolutely right that it could very well have a knock-on effect. So you think it would be better to let all of these come under property. Why would it be better to have a wide definition of property that includes body parts that have been taken out?
Maybe because we think of more extreme cases in which body part this might happen to more vulnerable people where body parts could be stolen from them, and they if we make a argument that once a body part has been removed from your body it is no longer your property, then people say at risk of organ trafficking or something like that might not be able to might have to find other arguments for a very reasonable argument that organs should not be stolen from people. But so this is collateral damage.
Yeah, I can certainly see that it strengthens, even though some people might argue we shouldn't see body parts as property because they're very different from our assets. I can definitely see your argument that in a way defining them as property can set a value on them and make sure that they are treated in the same way as those other assets for this purpose, and that can be a good thing. Absolutely. So then that's that point. And then the other point that you're saying is about the intention, which I think is a really, really interesting one. So if we go and act for the manicurist now, let's suppose we are, very keen on this artwork, it's amazing. What would be your best argument to say that the manicurist was not dishonest in doing this? How might we go about making an argument that because of the intention, this person isn't dishonest?
Well, you don't necessarily care about what happens to your nail clippings after you've been to the manicurist. So it's not a dishonest appropriation because you never asked what's going to happen with the nail clippings. Also, you know, it might be difficult for you to even pick out your own nail clippings. You might not even recognize it as your own, like, you know, without like DNA evidence or something like that. And you might not even find it, you know, like the nail clippings you might not find valuable unless they are part of this artwork that this artist has created.
Mm-hmm. Yeah, I can see that. Fantastic. I have one other question, and it's actually got nothing to do with theft, so we can take this this definition down. But I thought this was a really interesting question. Let us suppose that it would guarantee that no one ever did it again. Would it be right to impose the death penalty for running a red light? Let us suppose that if we did this, it would guarantee that no one would ever do it again.
No, I don't think it would be, for several reasons. One is it's a very disproportional punishment, and one person should not have to bear this punishment for, like, you know, so that, you know, like in the future no one else will do it. It's sort of like making an example out of someone, and one person should not have to bear that burden. Also, maybe, like, you know, arguments against capital punishment where state should does not have the right, you know, in terms of, like, you know, you're like violating fundamental human rights, but, like, you know, when the state takes a human being's life. So, yeah.
Mm-hmm. Let's suppose that the state says, but this will save dozens of lives a year because nobody will ever run a red light again. Would that make any difference? I suppose they've run the statistics and they can say we will save more lives than we will sacrifice under this rule.
Well, I suppose you could look at the flip side of, you know, that maybe a lot of people do run red lights, but they don't necessarily end up killing people, and it's a sort of like minor infraction, because it's not guaranteed that you're running a red light will kill another person. Maybe it's just very late at night and there are no cars, so you can run a red light, and that's actually maybe a logical decision to make if you're really in a hurry or something.
Mm-hmm. Let's suppose that it's possible to say that there's been at least one death a year from running a red light. Would that change your argument?
Well, yes, because it's still, I mean, I suppose the other argument that, like, one person should not have to bear the burden of, you know, future punishments that the other people could have because they've run a red light. It should not be, you know, borne by this one person.
Yeah, I can see that. Fantastic. At this point in the interview, I would always ask if people have any other questions, but I won't put you through that bit because presumably, given you're already at Mansfield, all your questions have been answered. And I do want to say for anyone watching this video that you don't have to ask a question at the end of the interview. People sometimes feel that they are under pressure to ask us something about our research or ask us what the right answer to the questions was. And it's not necessary. If you don't have a question, and people often don't have questions nowadays because we have a lot of answers on the website and in videos and so on. So nobody should ever feel under pressure to ask a question. The only other thing I would do at this point is to check if somebody has applied for the 4-year course, Law with Law Studies in Europe. I would ask them if they also wanted to be considered for the 3-year course if the faculty wasn't able to give them a place for the 4-year course. So all of those administrative things would also be taken care of at this point. And that would be the end of the interview. But I think it's probably helpful if we have a quick chat about how it went. I'm really interested to see how you feel it went.
I just found it really interesting, to be honest. One of my best friends is a law student, and like I love talking to her about all of the stuff that they're doing, because it's just really interesting to learn about. And it's also interesting how the like specifically you approach legal stuff, like in the definition of theft, like in everyday, like I mean, if you're just having a discussion, then you might consider something theft, but it might not actually, meet the legal definitions because there's a very specific definition of it, which I found really interesting.
Yes, and I was really pleased that you didn't try to bring in external ideas of what you think theft is actually defined in English law as, and instead you were making arguments about what you saw in front of you. And that's really, really important. So it's important in a law interview to look at the text and, yes, take time, go back to it, think again about everything that's in the statute. If you don't understand something, ask the tutors, they're there to help you. And not to try to say, oh, I think I heard that someone was guilty for this, so that must be the right answer, because I could easily be giving you something entirely fictitious at this point. And so it's really important to focus on what's actually in front of you. Of course, if you want to make arguments that say, well, I think that most people would understand the definition of theft to be this, I would absolutely have been interested in an argument to say, well, I don't think we should treat body parts as property because most people don't think of body parts as property. And that is a perfectly legitimate way to approach this. There are lots of legitimate ways to answer that question about whether body parts are property or not. And you gave one of those. There's lots of them. So nobody watching this should think, oh, those were all the correct answers. At every point in that interview, I was thinking of, several ways the conversation could be going. And there's lots of different things you could be emphasizing in that statute at lots of different parts of the interview. And that's just the nature of doing law interviews. There's nothing that's ever the same about them. And I think, it's really important to look carefully at the statute, and it's important to answer the question that's actually been given to you. And I think that was something else that you did really well. You didn't try to say, that's rather difficult, let's look at something else. You recognized the difficulty and you pinpointed where the difficulty was, because I'm never going to ask you something entirely straightforward.
Yeah, I think that's the thing, like, a lot of people give you this advice while doing interviews, is that, own up to it when you change your mind, or like, when you don't know the answer, and just talk through your reasoning. And I think that that's probably the most interesting part anyway, because these are questions that people spend, their academic lives grappling with. And there are so many theories behind it, and you can't just dismiss one and like have just one correct answer. So yeah.
Yeah. The example of the ball in the garden is actually one of the most difficult things on this particular bit of the Theft Act, because, as you said, you couldn't really say that there'd been an assumption of the rights of an owner. If we'd had time, I might have structured this differently, and we might have spent the whole 20 minutes talking about that. We might have gone into more the question of, were we saying that I hadn't appropriated, or were we saying that I wasn't dishonest? Obviously, we didn't really touch a lot on dishonesty. We looked at how we might construct an argument with the manicurist about dishonesty or not dishonesty. But we could, with the ball, also have emphasized that issue of dishonesty and explored what dishonesty means, because you did actually come close to that, and I considered going into it more with you when you were saying, what is generally accepted between neighbours?
Mm-hmm.
And we absolutely could have gone into that, because ultimately, when you think more about dishonesty, you can say, well, how do we measure dishonesty? Is dishonesty an objective concept that we can refer to? Because on the statute, it's actually quite hard not to say that I am guilty of theft, but on a common sense view, I personally would find it difficult to say I was a thief because I wouldn't let my neighbour collect their football. So I thought you did a good job with appropriation there, and I wanted to see how you would think about the third example, so I chose to move on at that point, but we could otherwise have spent time talking about dishonesty there. So yeah, that's an example of how a law interview might go. I wouldn't want you to think that this is the only way a law interview could go. So in this one, I deliberately chose, because I know Sruti hasn't done law, I deliberately chose a legally focused text. That wouldn't be likely to happen in an actual interview. It would probably be something that was either made up, perhaps taken from foreign jurisdiction. You would not be expected to know anything about theft or a typical common English law subject beforehand. It might be a longer piece that you read beforehand. It might be something else entirely, but it'll always be testing the same things, which is application, reasoning ability, and communication. So I hope you found this helpful. I've really enjoyed running this today. Thank you ever so much, Sruti. It was really, really great talking to you.
Thank you so much.
I think both of us would like to wish you good luck in your application. And thank you very much for watching.